Hey, this is Mark Freeley, the North Shore Injury Lawyer. Today I want to talk to you about depositions, or what we also call an examination before trial. And when my clients in a personal injury action hear that they have to appear for a deposition, they always tend to get nervous. And my job as a lawyer is not only to guide them through the litigation process, but also to give them a comfort to ease their anxiety when we're talking about depositions or examinations before trial. And simply put, a deposition is where the insurance company's lawyers have an opportunity to ask you questions under oath, where your testimony is taken down by a court reporter. So each question and answer is taken down, and a little booklet called a deposition transcript is created, and then it's sent to you after the deposition for you to review and to make any necessary changes, to execute it or sign it, and return it back to your lawyer. And so the purpose of a deposition is so that the insurance company and their lawyers understand exactly what the claims are, what you would testify to if the case goes to trial. And in New York State, we have a very open discovery process where each side basically has to show the other side their hands. And it encourages settlement, because if you know what would happen at trial, what the other side's um, defenses or arguments are going to be at trial, what evidence they have to put forth at trial. If you know that about their side and they know that about your side, it makes it easier for each side to evaluate the risks, the costs and the risks of going to trial, and it encourages settlement. And so that's one of the main purposes of the open discovery rule in New York, and why we have depositions. They also want to see what type of a witness you make. Are you credible? That's like number one. Are you credible? Are people going to believe your story? They're going to believe what you're telling us. Um, Number two is your likability, or are you likable? Are people going to hear what you have to say? They're going to see you and say, you know what, I like this person, and I believe them. And if you're likable and believable, you are a dangerous witness to the insurance company and their lawyers. They also want to see how sympathetic you are. You might be able to uh, adequately adequately explain what you've been through, how the accident happened, and what happened to you afterwards. But maybe you don't come across as that sympathetic, and that's another thing that they take into consideration. So they're going to start at a deposition just with some basic background questions: name, address, date of birth, social security number, where do you live, how long have you lived there, who do you live with, and just get a layout of your background. And they're going to slowly take you into the day of the accident. Where were you going? Where were you coming from? What roads were you on? What speed were you traveling? Where were you looking? Everything along the lines leading up to the point of impact. Let's say if it's a car accident, if it's a trip and slip and fall, same types of questions, just asking you why you were there, where were you looking, what type of shoes were you wearing. And so when we prepare someone for a deposition, we go through all the most commonly asked questions ahead of time with our clients, so you'll get a comfort level of what to expect come the day of the deposition. After they go through all the questions about how and why the accident happened, then they'll go into what physically happened to you and your body. You know, what body parts were injured, um, and they'll go chronologically through your medical treatment, starting with the hospital or the urgent medical facility that you went to, maybe your treating doctor or your orthopedist, your neurologist, and your physical therapist or chiropractor, and they'll take you through: when did you first see them, how many times did you see them, what complaints did you make, and they'll take you along that route. And then they'll get towards the end of the deposition. Well, they'll ask you two pretty important questions. Are there any things that you used to do before the day of the accident that you A, can't do at all anymore, B, you could still do them but not as well, or C, you could still do them the same way, but it causes you pain, or you pay for it after you do it. And then they're going to ask you, and what are your current complaints? And that doesn't mean just that day of your deposition, but in the last 30, 60 days, what are your pains or aches or issues in terms of what are you feeling? And that's basically what they're going to go through over a deposition. Of course, we would go into it more in detail on a case-by-case basis when we're preparing our clients. But I always tell my clients, listen, just be yourself. It's not a test. They're just asking you what you remember. And of course, there are certain things you need to remember and some things that are not that important, whether you remember it or not. You don't need to know you went to the physical therapist, 37 or 38 times. I always tell my clients to give answers when it comes to times, speeds, distances, or amounts. Give a range. If you give the least amount of times it could have been and the most amount of times it could have been, well then perfect. It's a home run every question. I tell my clients you want to get in and out of the question quickly. You only want to answer that particular question. Don't go on and on about something else. If there's something else the attorney wants to know, they're going to ask you it. So keep it short, keep it sweet, but also keep it honest. Don't embellish, don't exaggerate. The lawyers that take these depositions, they see right through it, and that's going to be a strike against you. So I tell my clients, just be open, be honest, just answer the question they're asked. And in terms of getting, nervous, everybody gets nervous at a deposition because most of us have never been through one. So take your time, listen to the question carefully. If you don't understand the question, ask the attorney to rephrase it a different way. They'll be happy to do that. If you need to take a break, you can take a break at any time and for any reason. Just if there's a question pending, you do have to answer that question before you take the break. I tell my clients, pretend you're talking to a neighbor or a friend and explaining how the accident happened and what happened to you afterwards. And just try to be yourself. And I think that's the biggest thing. Just try to be yourself, be polite, be friendly. Don't get into a fight with the lawyer and give them a reason to write a bad report to the insurance company, okay? If the particular attorney is annoying, and I know it's a shock, you would find an annoying attorney. But it can happen, and if that happens, ask to take a break, collect yourself, go back in the deposition, suck it up, get through it. It's one of the most important parts of your case, that deposition. So you don't want to lose control, lose your patience over it. It'll be over before you know it. And just be truthful and be yourself. And if you have any questions about a deposition, you can always give me a call at 631-495-9435 and keep it safe out there. Bye-bye.